Yes, the doctrinal legal research methodology. So before going into detail about the doctrinal research methodology, it is, I think, important to know to every human being from what are the windows by which we are gaining the knowledge about anything, about the facts, about the things which are happening around us. So I think you must be aware about the what are the windows. So you know that the entire study of any discipline, it is, I think, divided into two categories. That is the a priori method of thinking and the a posteriori method of thinking. And it was someone that he propounded first what is the a priori thinking and what are the a posteriori thinking. So in jurisprudence, all the things which either comes from our intuition, that is the inbuilt process of thinking, it cannot be developed through the inventions, through the human experiences, or through the thought process of the human being. It is automatically inbuilt in our mind. When the baby born, I think nobody can teach them how to suck a breast, how to suck milk from the breast of a woman. See, no, he or she know. That is to all the knowledge what we have, that is developed from the window of experience and window of ideas. That is the intuition. As far as the doctrinal research methodology is concerned, it is directly related to the theory, to the conventional or traditional methods which are already invented, which are already in existence. Whether you go in the library or you search on the internet, you will find that there is something which is already invented, but it is not the things. So doctrinal here only it means it is theoretical research, it is conventional research, it is traditional, and in nutshell it is also called library based research. And this is the most suitable and best suited methodology in doing research. The doctoral research asks only what the law is on a particular issue. It is concerned with the analysis of the existing legal doctrine and how the law is developed and what law is applied on a particular issues. So this involves analysis of case law, arranging, ordering, and systematizing legal proposition, and the study of legal institution. Above all, it creates law through lateral deduction. So it is also very difficult to say. Some jurists or some writers of the research methodology book, they have their own opinion. Some says that doctrinal legal research methodology is based on the deductive process, and some says that it is based on the inductive process. So what is deduction and what is induction? You must know induction is totally based on the pure experience, pure based on the pure senses, what we see, what we perceived through our five senses, that comes into the induction. And deduction is key, it is based on the pure generalization to specific matters. So it begins with the general to specific, and induction is based on the specific to general. So researcher must know about the both the process of reasoning, what is inductive reasoning and what is deductive reasoning. So I think entire gamut or entire process of research begins with the The entire process of research, it begins with the research problem and it ends with the conclusion. So I think research and for achieving the results, better result, either we go by the doctrinal methodology of research or researcher go by the non-doctrinal research methodology. So these are the two methodologies by which a researcher can find their conclusion and researcher can satisfy the questions which were framed earlier in their synopsis. So these are the two methodology, and it's in my opinion there is no another methodology for doing research. But someone, I think, misrepresenting the methodology with the methods and methods with the methodology and kind of research. So these are the things. So I think every time we must know about the methodology and also we know about the methods. The doctrinal research methodology, it is clearly based on the principles which are underlines or which are found in the library or which are found in the real textbooks, in the reference books, and by those we can generalize our problems, we can generalize our finding through the deductive process. So doctrinal methodology, I think it is the best format or methodology in research, especially in the domain of law. So it consists either of simple research directed at the finding a specific statement of the law or a more complex and in-depth analysis of legal reasoning. So research in this context, however, does not merely involve identifying information, but includes method of collecting information, reading, analyzing, criticizing, evaluating, comprising, and connecting the new idea to the existing one. And after all, there should be a general conclusion, and it must be give some, I think, it must have the some value of utilitarian aspect. It means what you have done through your research, it must satisfy the end of the society, what society wants. So the doctrinal research involves a systematic analysis of all the statutory provisions, legal principles involved therein are derived therefrom, and logical and rational ordering of the legal proposition and principles. Through doctrinal approach, through doctrinal philosophy of methodology, researcher must emphasize on substantive law, procedural law, rules, doctrines, concept, and judicial pronouncements. So the aim of researcher is to find out the right answer to a particular legal questions or set of questions or a statement of problem. So there are, so whenever you have adopted your topic, when your topic is finalized, so the next thing is after reading the topic, it should be clear what sort of methodology is pertinent to your research problem, to your research questions. So when researchers formulate their statement of problem, formulate their research question, automatically the methodology come to play. The entire role ki what methods are useful for what methodology. The methods is also one of the essential aspect of the methodology. The methodology is the whole process. It show the whole thinking process, and methods, it is like a tools. So after determining the research problem, researcher must aware about what methods is to be methodology and what method is to be used for finding out the solutions. So in this context, it is important to note that judicial responses, you know that the entire doctoral research methodology is based on the statutory law, based on the case law, and you also have seen that there is no a clear cut saying by the judiciary. What judiciary say today, maybe they either revert it or they rectified it tomorrow. So what law is for today may not be law for the tomorrow. So there is so many ambiguities in the decisions. Even when we are trying to say that our limit, what are the basic structure of the constitution, what are the limits of creamy layer, how much amounts a person earn to comes under the creamy layer, and what are the status of the minority. So these are the some concept, and that was the given by the judiciary. It is not in a final say of the judiciary. It may vary according to the circumstances and the changes happening in the society. So everything is have the change. So only the change is the, I think, the main variables, and otherwise what we are doing, it is correct for the time in which we have done it, and we cannot say that it is have the perpetual truthfulness in the future time to come. To sometime it is also very difficult to trace what are the ratio of the case and what are the obiter dicta of the case. So I think this is also a very important in doctoral research methodology, because whole gamut of this doctoral research methodology is based on either on the established doctrine, established theory, and the established case law. But there is nothing which can have the stability for all the time and which is true for all the time. The entire doctoral research methodology is based on the model, research model, that is called IRAC. IRAC means issues. What are the issues? What are your research problem? What are your questions? And on that issues, what rules, what laws, and what the available materials is now important to collect for finding out, for resolving the statement of problem, or for resolving the questions. And then the application, if there is a law, there is a case law, there is established principles, so you must apply that all the laws and all the established principles and all the case laws on your issues, and after that you will automatically be able to find out the conclusion after applying the laws, after applying the case laws over the issues. To application to IRAC, it functions as a methodology for legal analysis. So IRAC would consist of answer to a questions of legal research. So it relates to picking up the research problem, determining the relevant rule of law, analyzing the facts in terms of the law, which will then lead to the formulation of probable conclusion. So the facts of research problem are central to every steps in IRAC. So it is from this that the issue are identified. It means you have identified your problem, you have identified your questions, you have written your uh, research objective in your synopsis, and which in turn lead to the identification of the most appropriate rules, laws, facts which are related directly or indirectly with your issues. The analysis requires the interpretation, of facts and rules. The conclusion is the decision based on the application of the rules over the facts for each issues or each problem. So this is the final outcome of the doctrinal research methodology. It is theoretical, it is doctrinal, Doctrinal only means कि there someone have developed some principles and you are going to match your particular issue with the established principles or the doctrines. कि whether your particular issue, what you have identified through your research questions or through your research problems, and how much amount this doctrine is going to validate your research problem. So I think after observing all the available material, you will also be in able to find out your own conclusions. So conclusions should be your own for applying the doctoral research methodology, but the materials is not yours. You have collected the materials from the available sources. Sources may be primary or secondary. Data may be primary or secondary. But on the basis of that, you must have found your own conclusion, your own findings. So there are so many advantages of the doctrine legal research. So in crux, we can say that all the development of law, common law, especially the common law, were based on the doctrinal legal research. The judges judge what judge made law, the American jurisprudence. It is more concerned with the non-doctrinal research. But what jurisprudence were developed by the British judges or British common law, they were more related with the doctrinal legal research. So most of the development of law is originated from the innate idea or from the minds of a person. Ki what law should be, what is the gaps you are seeing, you are observing in day-to-day life, what law is applicable, what law is not applicable in the current time. So these are the some areas, especially most of the laws were developed by the doctoral research. Most of the, I think, researchers nowadays are happening with the using doctrinal legal research methodology. So it is clear that it is a traditional method for conducting legal research and is often taught during the early stage of legal training at the law schools or joining the bar. So whenever a person join the bar after graduating in law, or whenever you see the judgments, you find that there is no empirical study done by the judges. Only the liars they have do something, but judges, what the materials and what the things produced before the judges, to judges most of the time they either synthesizing through their judgments, and synthesizing is nothing, it is the whole concept of thesis and antithesis. So most of the, and after doctrinal research, a researcher may predict some better ki what should be the future laws, because it is begins from your imaginative faculty of mind. Idea comes from your imagination, and imagination is not bound to come from the experience. It is behind the experience. It is something in our, I think the most of the philosopher in our country, they have thought about the behind senses. What is behind senses? What is transcendental aesthetics? So these are the things which cannot be proved through the sense experience. The mind, you know that the mind have no limitation. Mind can think whether what we think today, we can think that the golden mountain, but it is the duty of the science. It is the work of the science to go and search whether our what we think today, it have the possibility, it have the potential to solve the problem for the tomorrow. But we can think. So thinking, but your thinking, I think must be started from your own self, but it must have the potential to satisfy the end of the society. So these are the some advantages. In nutshell, we can say that doctrinal legal research methodology, it develops most of the law which we are studying today. Even you know that the law is not a material science, it is a formal science, and it comes first into the idea of human being, what should be the law. And it is not the study of what is the functional approach of law. It is the later on, it studied begins in the 19th century, in the 21st century. Earlier, when human came into existence, they have only thought about should. They not thought about the concrete things. They not thought about the materials. They have the thinking. So in nutshell, what Professor Upendra Bakshi observed that law society research cannot thrive on a weak infrastructure base of doctrinal type analysis. This is the demerits of this principles. Doctrinal legal research, the legal and policy studies of the state of law provide not merely an assurance of sound understanding, but also hold premise of needed starting point for socio-logical approach. So doctrinal legal research is essential for identifying issues, delimiting the areas of researchers' inquiry, formulating apt hypotheses for inquiry, and devising appropriate strategies and tools for collecting relevant data. In the absence of these preliminary requirements, the sociological will be like a boat without a rudder and compass left in the open sea. So I think the doctrinal legal research methodology, it is the only methodology which gives the base for every kinds of research, whether research in science, research in any discipline, any social sciences, that is the law. So it gives the founding stones, it gives the base of the all the research. So without the thinking, without the idea, how we can proceed further? Empirical study, it only begins with the idea, with your hypothesis. What hypothesis we are going to make, or we had made in the synopsis, it is begins with the mind. It is not on the empirical study. After making the hypothesis, then we are starting what materials are required, what data are required, then the empirical study is required. So I think the doctrine research methodology, it is the basis, it is the initial point of the beginning of the research. Whether we are observing in day-to-day life what is happening around us, but we must emphasize first what the concept, what the idea begin in our mind to resolve the issues. So this is the doctrinal legal research methodology. So these are the some limitation on doctrinal legal research methodology. You know that it is too theoretical, technical, conservative, trivial, without due consideration of the social, economic, and political significance of the legal process. It is too restricting and narrow in its choice and range of subject. It is rarely converting the social facts and values which are existed in community. It has no connected with the actual working of law. and their consequences in relation to society. The doctrinal legal research does not involve in the factors that lie outside the law. The researcher puts his sole reliance on traditional research sources of law and judicial pronouncements of appellate courts. The actual practice and attribute of lower courts and of administrative agencies with quasi-judicial powers whose judgments remain unreported or left unexplored. So these are the some limitations, and through the non-doctrinal legal research, these demerits can be resolved. Otherwise, doctrinal legal research have their certain field in which researcher can do best research, but what is the real impact of other discipline on the law? What is real impact of social facts on the law? What is the functional approach of law? This is the questions and this is the things which are unleft or unexplored through the doctrinal legal research. So at this juncture, there is need to non-doctrinal legal research in which the real approach or the concrete study is required. Non-doctrinal legal research, it is the research which is based on the concrete data, which must comes under the sense perceptions, which is not comes through the window of idea, which must comes under your sense perception. It means which have the concrete existence, which can be measured, which can be numbered, which can have the some mass, weight, time, space. It is the most important things in the non-doctrinal legal research methodology. It has some measuring instruments. It requires some tools, techniques by which the concrete things, the concrete idea can be measured. Conducting research in law by using empirical research methodology is of recent version. So it is believed that non-doctrinal legal research or empirical research methodology, it is carried out with the help of observation, experiment, and the field visit. It also believed that it emerges through the sociological jurisprudence. So when the sociological approaches, the functional school of law, the empirical study of law developed, the American jurisprudence developed, the realistic approach developed. So these are the philosophies, sociological philosophy, realistic approach. So by this approach, the empirical study begin in the law. The most non-doctrinal researcher seeks what is the impact of non-legal subjects on law, and why, as you know that in positivism, especially what Kelson propounded, law is complete in itself. Law has no requirement to relate with the other subject. It is self-contained subject. But after the advent of the sociological school of jurisprudence and the realistic school of jurisprudence, all the philosophers and all the jurists of these particular schools, they have thought that there is something, law cannot exist in the vacuum. There is a need of society for existing the law. When we begin our thinking, so our thinking must rationalized into the existence of the society. So most of the jurists, they have also said that law, purpose of law is to resolve the conflicts to resolve the problems which are in the society, and what is the impact of law on the other subject, and what is the impact of other subject on the law. So it is the, I think, the interdisciplinary research. So when we are talking about the interdisciplinary research, it is clear that it requires non-doctrinal approach, empirical study, because without knowing the nuances of the exact empirical study, what empirical study means, we cannot treat on a way to find a better result. To identify and appraise the magnitude of the variable factors influencing the outcomes of legal decision making. So what are the things that impacted judges for delivering the judgments? Time, surrounding, space, debates, what is debates happening in the TV, and what are common people thought about the judicial process. So these are the some things which impacted. We have seen that when the judges pronouncing the judgment, or when judges the handling the cases, before interval they have their special minds, and after the interval, after 2 o'clock in the afternoon, they have their own mind. So most of the lawyers, they have observed that in the morning session, judges played a very significant role in decision making, and in the afternoon session, they have played very less role to any significant judgment. So why this happened? So it requires what things change the attitudes of the judges, what external forces, what extra things, and what things that impacted on the minds of the judges, why they have the different opinion. By the time in the morning time they have the different opinion, in the evening time, why they cannot persist on the same opinion all the time. So these are the things which impacted the behavior of the judges, and it also reflected in the decision making process of the judiciary. So to find the gap between the legal idealism and social reality, I think thinking is better. We can think without boundary, but the real approach is it have the boundary, it have the limitation. In thinking, there is no limitation, but in reality there is a limitation. So what we are facing the reality and what we are thinking, both have, I think you have also know that in theory and practical there are so many differences. We can write a better theory, but practical of that theory is very difficult to rationalize it in concrete sense in the society. So to study the impact of legal process upon people, their values and social institution. So a number of factors that lie outside a legal system may be responsible for non-implementation of some laws. We every time discuss about we have the abundance of law. We have a plenty of law on any subject, but due to lack of implementation, we cannot rationalize our ideals which are embedded in the preamble of the constitution, or which are embedded in the every of statutory laws. You know that the every law have their subject or the object for which they have made. To implementing, what are the factors why we cannot implement the law in a better way, why the judgment of the judiciary cannot implemented by the executive in a concrete way. So where there is lacking, so due to, I think it is the non-doctrinal research methodology by which we can resolve the issues of non-implementing factors. We can resolve the issues of the factors which are impacted the judge's mind. We can, I think, give a new solution to all the happenings in the society. So there is a certain gap between actual social behavior and the behavioral demanded by legal norms. So you know that the early philosopher described as empirical research is the process where a conclusion is totally depends on observable data to formulate and test theories with the reasonable sense. The entire philosophy of non-doctrinal legal research is based on self-created data. That's why it is called the pure research. It is called original research. So if you are going to adopt this methodology, so I think your result should always be based on your self-created data. But nowadays, most of the empirical study that is done by the students of law, they are not purely based on their self-created data. They are most of the researcher, they are based on the secondary data. So in doctrinal research methodology and socio-legal research is also called socio-legal research. Why it is called socio-legal research? Because it has connection with the other discipline. So these are the some questions. Whenever people or the researcher going to adopt this methodology, they must ask these questions. Ki are laws and legal institutions serving the needs of the society? What law is in the statutory book, that is the dead letter of law, whether that law have the significance for the serving the needs of society. If it is okay, so then it must be continued. Otherwise, if it is not okay for the existence of the society and for the betterment of the society, so there should be some fresh researcher must be from the scholars. So are they suited to the society in which they are operating? So this question also must be observed by the researcher, and what forces in society have influenced shaping or reshaping a particular set of laws or legal norms. So these are the some questions, and it must be known by every research scholars whenever legal research scholars going to adopt research methodology. This type of research methodology. So legal researcher undertaking non-doctoral legal research takes either some aspects of law or the people and the institution supposedly regulated by law as the force of his/her study. The researcher is usually required to undertake fieldwork to collect data for seeking answer to ascertain questions in their research. The non-doctrinal legal research. So this is the, I think the what people have thought, what people have the problems, whether the problems can be resolved by the research. So these are the some questions of the non-doctrinal legal research. The non-doctrinal legal research aims at highlighting the gaps that exist between the law in the statute book or statutory law, that is the image of the law projected in the books, or that is the crux idea that is written in the every, I think, object of the statute, and law in action, that is the perception it exhibits in reality, an impact of law on the social behavior. So entire genesis of the non-doctrinal legal research, it begins with the gaps, it begins with the shortcomings, lacunas, and which can be easily perceived by a human being, and it can also be sorted out through the data and all the self-created material from the scholars. What are the advantages of the non-doctrinal legal research? You know that the socio-legal research highlights the gaps between the legislative goals and the social reality, and thereby depicts true picture of law in action. The empirical legal research carries significance in modern welfare state, which emphasizes socio-economic transformation through law and thereby perceives law as a means to achieving socio-economic justice and parity. So, through empiricism, socio-legal research assesses role and contribution of law in bringing the intended social consequences. This sort of research also helps us in ascertaining impact of law on social issues, values, outlook, and attitude towards the change contemplated by law under inquiry. Non-doctoral research also provides an expert advice and gives significant feedback to the policymakers, legislature, and judges for better formulation, enforcement, and interpretation of the law. The socio-legal research renders an invaluable help in shaping social legislation into with the social engineering philosophy of the modern state and in making them more effective instrument of the planned socio-economic transformation. And there is also some limitation on doctrine legal research method. Though socio-legal research has great potential, yet a few limitations thereof need to mention here. First, it is extremely time consuming and costly as it requires a lot of time for collecting the required information from field. Further, it calls for additional training, designing and applying tools of data collection. Socio-legal research needs a strong base of doctrinal legal research. A legal scholar who is weak in doctrinal legal research cannot handle non-doctrinal legal research in a meaningful way. It may turn out to be a futile exercise leading to the no significant result. It means if you are not, I think, well in the doctrinal legal research, if you have no idea of doctrinal legal research, so you cannot treat any further step from the basis of non-doctrinal legal research. You must know first what is doctrinal legal research all about. Then you, I think, try to adopt non-doctrinal legal research. So the basis tools of data collection, namely interview, questionnaire, schedule, and observation, it is not a simple to employ. They require specialized knowledge and skill from the stage of planning to execution. The researcher has to have a sound skill oriented training in social science research techniques. A well trained social scientist cannot undertake social legal research without having sound base in doctrinal legal research. So, similarly, a scholar, though having a strong base in legal principles, concepts, or doctrine, as well as in doctrinal legal research, cannot venture into non doctrinal legal research unless he has adequate training in social science research technique. In either case, non-doctrinal legal research became a nightmare for both of them. A way out, therefore, seems to be an interdisciplinary approach in investing legal problem. To invariably, public opinion influences contents and framework of law. Law most of the time also seeks to mold and change the public opinion, social value and attitude. In such a situation, sometimes it becomes difficult for non-doctrinal legal researcher to, on the basis of sociological data, predict with certainty the course or direction the law needs to take or follow. Such a prediction involves the maturity of judgment, intuition, and experience of the researcher. So he may fall back to doctrinal legal research. So nevertheless, sociological research may be of some informal value to the decision makers, sometimes becomes because of complicated social, political, and economic settings and varied multiple factors. Socio-legal research becomes inadequate and inept, where the problems are to be solved and the law is to be developed from case to case. To all, you know that all the laws of torts and the administrative law, they are developed through the doctrinal legal research methods, not through the non-doctrinal legal methods. So, in nutshell, we can say that doctrinal legal research methodology and the non-doctrinal legal research methodology both have played a significant role in the development of law. To be never say that कि without knowing the nuances of all the doctrinal and non-doctrinal legal research methodology, we cannot do better research in the field of law, whether it have some impact on the social facts, whether it have some relation with the other subject, or that is called nowadays transdisciplinary research, multidisciplinary research, and interrelated research. The law have the relation with other sciences also, other subject also. So with the help of both doctrinal and non-doctrinal research methodology, researcher can give a better fruitful result for the society to subserve the end of the society. The current trends in the legal research, so you know that the goal of legal research is to ascertain relevant jurisprudence and analysis of legal issues to solve legal problems. As a consequence of COVID-19, and you are well aware about that, the use of technology has become necessary for research in all disciplines, including legal studies also. So more cross-disciplinary legal research with the social and behavioral sciences has emerged nowadays. The technology and the impact of Internet of Things has also influenced legal research methodology. So whether you are going to adopt non-doctrinal research methodology or doctrinal legal research methodology, we cannot deny the importance of the IoT, which really influence all the methodology. So nowadays, we cannot do a single steps in the research without the using of IoT, without the using of recent emerging tools and techniques. The use of technology has advantage of saving time, speed, ease of research, abundance of resource material, accuracy of result also. So for all these things, to these there is a shift from monodisciplinary legal research to transdisciplinary legal research. So this is the, I think, the most important in day-to-day beginning. To recent happening, you have also seen that Kisan Andolan, without much deliberation on the farmers' law, Parliament passed a bill, and after I think after agitation of approximately 1 years, all the laws relating to farmers they are called off, and they are can I think not in existence. The impact of COVID, you know that emerging trends of digital technology and virtual hearing by various high courts and delivery of justice. So there is a lot of change happening in current day-to-day business, either by the judiciary or by our thinking, even the classrooms. We are in the COVID period have taken most of the classes through virtual mode. So, what is the impact of virtual mode on the students of law and also on the teachers, and what is the legal impact? So, it is also one of the subject on which we can do a research better through the doctrinal and non-doctrinal methodology. So, social networking and social media. So, these are the some things, and these are the recommendations in concrete. We can say that invest in yourself as a researcher. You must be a good researcher. You have some inquisitive mind, curiosity to know, and you must enlarge your existing knowledge. Educate yourself by switching to electronic mode. Check all information carefully. Use multiple sources of information. Be more cautious. Prepare for change. So this is all about the today's deliberations of my lecture. And if you have any questions, so please may ask.
Thank you, sir. It was an insightful session, and we feel privileged that we got an opportunity to have your knowledge, to share your knowledge with us. Again, I say thank you for enlightening us, sir. Now we'll begin with the doubt session, and it will be taken by the Vatsal, sir. I'm handing it over to Vatsal.
Thank you, sir, for such a great lecture. I am Vatsal Chaudhary, teaching associate from Starex University. I'll be moderating the question and answer session. The first question has been asked by Ms. Muskan Arya. She has asked that how can we remove ambiguities in law?
Okay, you know that this is not a work of student or researcher. We can suggest how to remove the ambiguity. It is the special duty of the courts, because you know that the final interpreter of all the laws is the court of our country, that is the highest court. Supreme Court and high courts, they have the potential to say how to remove the ambiguity. Our duty is what are the ambiguities in the existing laws, sort out the ambiguities, and then file a petition to the court. And you also suggest some your ideas how to remove. This is the research. So you must do research on the ambiguities of the existing laws in your particular subject in which you have seen most of the ambiguous things are used. So I think this is the proper answer. You know that the interpretation, we are not interpreter.
Sir, next question has been asked by Ms. Meenakshi. Her question is, what factors one need to consider while doing research with respect to recent judicial pronouncements?
Yes, this is the most, I think, important topic nowadays, and it is a burning topic. And we also think this on this topic. To recent pronouncement, in what sense you are saying the recent pronouncement of the judgment? All the judgments which are recently pronounced by the courts, we have no problem. I think there are some judgments, it may cause some problem or it may require some fair comments. So what judges do in their actual judicial behavior, you know that that is also law. So we can only a fair, we have the right to only fair comment on the judicial pronouncement. But we can collect a data of the what judgments are given by the judges in recent 2 years, and what impact this judgment have on this society. So you know that there is every time there is a two ways. Either we think antithesis or we think thesis, and the judges are the synthesizer. Their role is how to synthesize the idea of the counsel for the petitioner and idea of the counsel for the respondent. But after judgment, it when it became, yeah, when it comes into the public domain, it is our duty to say what such judgments have the impact on the society. So every time we have, I think, some thinking about the judgment, but we must criticize it fairly. So we can do research, empirical study, ki what are the impacted of the recent pronouncement of the judgment by the apex court or the high courts on the common people of the country, or especially in the bail matters. Recently, Justice, I think Chief Justice of the Supreme Court, Justice Ramanna, said in a conference, 80% of the prisoners, they are the trial prisoners. So why? And they have the right to bail. Most of the cases, I think, may have the right to bail. So it is on the judiciary or it is on the government also. There must be some coherence between the functioning of the government and the judiciary both. So sometimes we see that executive is liable and sometimes we cannot say judiciary is liable. Okay, empirical data can be collected, and on the basis of that empirical data we can say something, what is the real impact of the recent happening by the judiciary or judgment. Yes, any other questions?
Good afternoon, sir. Now I would like to request Mr. Vatsal for vote of thanks.
Thanks a lot, sir, for enriching our legal knowledge with such a great lecture. I'd like to apprise our esteemed speaker, Dr. Bhatt, of the fact that his lecture has made a far-reaching impact on our legal know-how. Some key points, which in my view were of utmost importance, were relating to doctrinal research model, advantages and limitation of doctrinal legal research, advantage of legal research, limitations of non-doctrinal research. Thanks once again, sir. With this, our session comes to an end. Next session will commence from 1 p.m. sharp. And please don't forget to fill the feedback form for this session. You can find the link for it in the chat box or in the WhatsApp group. Thank you.
Okay, thank you everyone for listening patiently. What I have delivered today may not be able to deliver tomorrow. So it is a mind. And I have told, as I have told earlier, the judges, mind of the judges, it is vary from first half and the second half. So there is nothing constant. And that's why it requires some research. Okay, thank you everyone. Thank you, and I'm very thankful to my people are sis Baswa Sharma
Thank you, sir.
and Prerna
Thank you, sir.
Rashmi.
Yes.
Starex University. So thank you. God
Thanks.
bless you all.
Thank you so much, sir.
Thank you.